No, I'm just going to tell. I'm going to tell them. All right, folks, we're back in session. The jurors are in the jury room. The defendant and counsel are present. I've been advised by the bailiff that the jury foreman has told her that the jury has arrived at a unanimous decision, and they therefore have a verdict in this case. They also handed me a note she's handed me a note signed by Mr. Mock, as full person of the jury, in which the jury has indicated they'd like to be escorted out of the building in some manner as to restrict access to them and be escorted to the parking garage, and I'm going to honor that request. I'm going to follow my tradition of advising the jurors that I have not released them from their jury service until they leave the courthouse, leave the parking garage, and arrive at their destination. Until such time as they're released from the jury service, no one can contact them or attempt to talk to them about the case. So please, everybody, be aware of that. If you were inclined to think about doing that, don't. You'd be in violation of my order, and I know you don't want that to happen. So I'll honor the request. Also, I don't know the people who are here, but people who are here, obviously some of you have some interest in the outcome of this trial. I don't have a clue what this jury verdict is going to be. However, whether you agree with it wholeheartedly or you disagree with it vehemently, whatever your feelings are, keep them to yourself. I don't want anything said by anyone in this courtroom that would cause any kind of disruption that would cause me to have a contempt hearing in this matter. Please honor and accept the integrity of this jury, no matter what their verdict is. All right, Madam Bailiff, can you bring the jury in, please, and bring all the items in, too, that they have, please? Yes, tell them to put everything in the box and give everything to you except the full person needs to have the original verdict sheet, okay? Yes, thank you. Thank you, Sheriff. Mr. Mock, the foreperson of the jury, I inquire of you. The bailiff indicated that you have reached a unanimous decision, and, sir, is that correct?
That is correct, Your Honor.
Have you recorded that on the verdict sheet?
Yes, I have.
Okay. Hand it to the bailiff and let me take a look at it, please. Let the record show that the verdict sheet has been signed by Timothy E. Mock as foreperson of this jury. Mr. Mock, you have reported that it is the unanimous verdict of the jury that the defendant is guilty of murder in the second degree. Is that correct?
That's correct,
Okay.
Your Honor.
Ladies and gentlemen, your foreperson has reported that it is the unanimous verdict of the jury that the defendant is guilty of murder in the second degree. If this was the unanimous verdict of the jury of murder in the second degree, and this is your individual verdict of guilty of murder in the second degree, would you indicate that, please, by raising your hand? Let the record show that all 12 jurors so indicated. The court accepts the verdict and orders that it be recorded. Let me thank you, ladies and gentlemen, for your service. Let me thank you for your verdict. During jury selection, we did not tell you that this task would be easy. In fact, far from it, we all knew that it would be one of the most difficult challenges that you faced in your adult life. When 12 people deliberate, you face the reality that there are many things in life that reasonable men and women disagree about, because we all come from different places in the world and different backgrounds. But on behalf of the citizens of Lake County, the court system, and the parties, and a very grateful community, we thank you for your jury service. We thank you for the hardship and the personal sacrifice over the last 5 weeks. We thank you for your integrity and for your strong resolve to carry out this extremely important civic duty, to search for and find and declare justice by your verdict as you see it. And we certainly accept your verdict. I told you that in the beginning that this is democracy in its purest form. When important decisions are made in this courtroom, I don't make them, no judge does. 12 citizens make these kinds of decisions, and that's what you've done. We have created a society in which we summon citizens here to form a committee of 12 strangers, to address a really important issue with regard to a serious criminal charge, and to be satisfied by their verdict individually and collectively beyond a reasonable doubt that their verdict is correct, and they all must unanimously agree. Amazingly, it works. It works. It's worked for 200 years. Hopefully it will continue to work. I feel very strongly that it's one of the things in government that still actually works the way it was originally intended. We thank you for helping it work today. We thank you for your effort to find a just verdict, and we accept your verdict as a just verdict in this case. The only reward that you get for jury service is the knowledge that you've done something really important for justice, and you've done something really important for the democratic way of life. They take your name out of the computer now for 2 years, so you will not get called back for jury duty for 2 years. Lauren Freeman, the high clerk of this court, will send you a check in a week or two. The amount of that check is an absolute insult. If we paid you for the value of your services, you know and I know we could not afford to have you here anymore. So then we could afford to have some kid over in Afghanistan or anyone else participating in government to carry out some civic duty on their part. You have requested an opportunity to be free of any type of inquiry, at least right now. And I'm going to honor that request. And you've asked to be able to be escorted out the building and to the parking lot free of any type of disruption so you can get on with your life now that you've finished your obligation to this court. What I'm going to do is I'm going to advise you that I do not release you from your jury duty, your jury service, until such time as you get to your vehicle and you arrive at your intended destination. At that point in time, you can talk to anybody you want to about this, or choose not to, as you see fit. But until you reach that point in time, no one can talk to you. No one can talk to you about this case. There may be people who want to talk to you about it, and you are absolutely free to discuss this matter with anyone. You can read anything about it, watch anything on TV about it. You can actually go back and watch this whole trial again, frankly. Or you can choose not to and get on with your life. But let me just say this. In that jury room, only you 12 people know your conversations and discussions. And if you choose to speak your own mind about how you felt, but don't speak the mind of someone else. Protect their own feelings, opinions, and confidences that they shared with you. We'll destroy all your notes and records, and we will release you at this time with our thanks. If you'll leave your badges with the sheriff on the way out, I personally thank you for your service. You're excused. Thank you very much. We're going to ask everybody else to remain in the courtroom, please. I'm not going to authorize anybody to leave for a few minutes. The jury is absent. The jury having returned a unanimous verdict to the charge of murder in the second degree. Court having accepted the verdict and having polled the jury, and the jurors all 12 declared that to be their individual verdict and their collective verdict. This is state prejudgment. Jury having found the defendant guilty of the B2 felony of murder in the second degree. Although the prosecutor declared that there were aggravating factors in the case as a result of the failure of the prosecutor to set those forth in the bill of indictment, since the alleged aggravating factor in the case was that the crime was committed in the presence of the children that had to be alleged in the indictment, and therefore the maximum sentence authorized by law for this offense is the minimum sentence of 157 months in jail, there being no aggravating factors.
That's correct, Your Honor. And Your Honor, the only thing that the state would argue to you in sentencing is that it's clear by this jury's verdict that they rejected the defendant's assertion that she wasn't involved. You've heard that evidence through these two trials, and we'll leave it in your discretion.
All right. Does the defendant through counsel wish to be heard?
I can appreciate the situation that Ms. Hayes is in regarding the jury's verdict in light of the evidence in the case. However, I would ask the court in determining the appropriate sentence for Ms. Hayes to consider certain factors that the evidence did support regarding her situation as it related to Mr. Hayes, but for her relationship with Mr. Hayes, it is extraordinarily unlikely that Ms. Hayes would have ever found herself in a courtroom of any kind, ever. And it is our position, and we are still steadfast in that based on our understanding of Ms. Hayes, as well as what we have learned about Mr. Hayes, much of which has been elicited through the state's witnesses in this courtroom, and largely came through Laura's words through the parenting history survey that was shared with us through Heidi Schumacher. There is no reason to believe that Ms. Hayes suffered any less domination and abuse than Laura talked about and discussed in her case, albeit it's our position that it was more mental and emotional, and her dynamic was different. And during the time of this offense conduct, it's our position that Ms. Hayes was under some duress and coercion and compulsion that was driven by Mr. Hayes. And it is illustrated very dynamically and very dramatically how he moved in on her. She was living a happy, law-abiding life in the Virgin Islands, working 2 or 3 different jobs, and had gone to New York to help her daughter, be a chaperone for her daughter to go to school. And he created a situation through guilt, saying that her boyfriend was causing him, or was threatening his life, and he as a predator, I think the evidence is very clear that Mr. Hayes had a determined agenda with Ms. Hayes, and she did not have the psychological or emotional defenses to understand that, and he moved in on her and took control of her life, and took control of her finances, and moved her down here to North Carolina. And by the time this offense conduct occurred, she was 5 weeks pregnant, homeless, broke, and he obviously drove the offense conduct, and I would ask you to consider that as a mitigator. It's our position as well that in the homicide itself, it was based on the autopsy of strangulation, possibly a stabbing. There's no evidence at all that Ms. Hayes ever touched Ms. Ackerson, and to that extent, I would argue that she would have been more of a passive participant or played a minor role. She was 5 weeks from having a baby. She had had a C-section. She had been in a state of depression prior to even having had the child, based on the testimony of Shay Goodott, her daughter, who found her crying and distraught a month before the baby was born, because Mr. Hayes had not only run through the savings that she had from the death of Mr. Smith, but had pawned all the jewelry that she had of any value, and had maxed out her credit cards, and she was finding herself alone and broke and dependent on a man who could not provide for her, and was discussing with her daughter how she might extricate herself from that relationship. Prior to this, mitigator number 12, she's been a person of good character and had a good reputation in every community that she's been in. You've not heard one bad word from any witness about her in this courtroom. Prior to Mr. Hayes running through her money, selling her jewelry, and maxing out her credit cards and leaving her penniless, she supported not only her family, but his. She's had a positive employment history throughout her career, her life. She's maintained various forms of employment, even when she had enough money that she did not have to work. Ms. Hayes was continuing to gain employable skills and actually employing those skills in gainful employment. And I would ask the court to take all those factors into consideration. She has, through her relationship with Mr. Hayes, found herself in this situation, and the jury's verdict is what it is. But she has lost custody of her infant child, which is a tremendous loss to her, and she will face a lengthy prison sentence, whatever you decide to do. And I just would ask the court to search for some balance in the mitigation. Certainly what happened to Ms. Ackerson is disturbing to everyone, including Ms. Hayes, but I would argue to the court, had Mr. Hayes met Ms. Hayes first and Ms. Ackerson had been second, it could just as easily have been Ms. Hayes that was the victim in this case.
But that would have required Laura Ackerson to participate in the killing of Amanda Hayes. All right, and Ms. Godwin, my problem, I think, here is that I personally believe, based upon my view of the evidence, that it is quite possible and likely that Amanda Hayes could have saved the life of Laura Ackerson, and she chose not to. She chose instead to participate in her killing. Have you advised the client of her right to speak? Sure.
I think she does want to address the court, Your Honor.
Okay. Ms. Williams.
Your Honor, I would just like to apologize with my whole heart and soul, firstly to Laura. I apologize to her family, to her children, to my family, to Grant's family, to everyone who had to work this case, to everyone who had to sit through this trial, to everyone who in the media has had to watch this and that has touched their lives. I'm so sorry that this touched my life in any shape, form, or fashion, or anyone that I love or care about, or anyone. And I'm truly sorry with every ounce of my soul.
All right, please stand up. Defendant having pled not guilty to the charge of murder in the first degree, the jury having heard the evidence and returned a unanimous verdict of murder guilty of murder in the second degree. State having prayed judgment, the court finds the defendant has no prior record. At a prior record level, therefore, of 1 for a black class B2 felony, at the top of the presumptive range, the judgment court can be sentenced to a minimum term of 157 months in North Carolina Department of Corrections and a maximum term of 198 months in North Carolina Department of Corrections. This is an active prison sentence. Give her credit for the time she's been in jail, waiting trial on charges. She's in custody of the sheriff. Thank you. Any further? Sheriff, let's adjourn the court, Sonny Dye.
All right. Oh, yes, it's on the court. Now adjourned. Sign it out. Gonna say statements on the court.